Right now, somewhere in your country, there is a law. It says that if a man forces sex on a woman against her will, he will be arrested, charged, and imprisoned. You have never had to think about what life looks like without that law. But for the vast majority of human history, it did not exist. No police, no courtroom, no word for rape as a crime against a person. Just a small group of people, a fire, the dark, and whatever social rules they had managed to agree on. So what actually happened? The answer is more complicated, more brutal, and in some cases more surprisingly protective than anything you would expect. To understand it, you have to start with what kept any behavior in check before law existed. In a band of 30 or 40 people moving across a landscape, there were no prisons, no judges, no written codes. What there was something far older and far more powerful: reputation. In a group that small, everyone knew everything about everyone else. A man who harmed someone in his band did not face a courtroom. He faced every person he depended on for food, for shelter, for help when a predator came at night. Anthropologists studying small-scale societies found that the primary punishment in egalitarian hunter-gatherer bands was reputational, gossip, shaming, and ostracism. And ostracism in the Paleolithic was not embarrassment, it was a death sentence. You could not survive alone. This created a social structure with real physical consequences for violence inside the group. And the data bears this out in a way that should surprise you. In 1981, anthropologist Peggy Reeves Sanday at the University of Pennsylvania published a landmark study examining 95 band and tribal societies from across the world. What she found challenges everything we assume about human nature. 47% of those societies had no rape, or rates so low they were considered negligible. Nearly half. These were not utopias. These were groups of people living hard, dangerous lives in the wild. But in societies where men and women were considered equally indispensable, where women's roles carried the same ceremonial and social weight as men's, sexual violence was essentially absent. The deterrent was not a law, it was the group itself. But here is where it gets darker, because Sanday also found that 18% of those same societies were definitively rape-prone. And what made them different was not biology, it was culture. Rape-prone societies shared the same features across every continent: male dominance, physical separation of the sexes, and a social structure where women's worth was defined entirely by their relationship to a man. In those societies, a woman who was raped was not the victim, the man she belonged to was. When the first written rape law appeared in Babylon around 1750 BCE, the Code of Hammurabi did not punish rape as a crime against a woman. It punished it as property damage against her father or her husband. The woman herself was almost incidental to the law. If a married woman was raped, she and her rapist could both be sentenced to death by drowning. Her husband had the option to pull her out of the river. The rapist got no such offer.
The ancient Assyrians went further. Their legal code, developed between 1450 and 1250 BCE, followed a logic so brutal it is almost impossible to read. If a man raped a virgin, the punishment was not imprisonment. It was that her father could rape the rapist's wife, the woman who had done nothing, the one who was not involved at all. She became the instrument of justice, because in that world a woman's body was not hers, it was an asset, and the only way to restore the damage was to damage an equivalent asset belonging to the man who caused it. What is remarkable is that this shift from rape as a social violation punished by the group to rape as a property crime punished by the state actually made things worse for women. In small, mobile bands where everyone depended on everyone else, the social cost of harming a woman inside the group was real and immediate. The moment civilizations formed, built hierarchies, and wrote down laws, women lost whatever informal protection the group had offered, and gained instead a legal system that treated them as someone else's property. The first law that defined rape as a crime against the woman herself, not against her father, not against her husband, but against her, did not emerge until 6th century Rome, when the Emperor Justinian revised the legal code after more than 1,000 years of written law that had gotten it wrong. Celtic law in pre-Roman Britain, somewhere around 1000 BCE, had actually recognized it centuries earlier. But no one was listening. Your body carries no memory of any of this, but the social structures that either protect or endanger women, the presence or absence of female coalitions, the degree to which women are considered equal partners in a group, those variables have not changed. Sanday's findings from 95 tribal societies predict rape rates in modern nations with striking accuracy. The law arrived late. The culture was always the thing.